Good afternoon, and welcome to Facebook Live from Chisholm and Kilpatrick in Providence, Rhode Island. Today we are going to be discussing Part 2 of Top 10 Court of Appeals for Veterans Claims cases. If you have not done so, please watch Part 1 of this series, which we taped last Thursday. It is on our website, which is www.cck-law.com. And while you are watching today, we'll do a quick refresher, and then we're going to talk about some more, the rest of the top 10 cases, which we'll get to in just a second. Please feel free to ask questions. We have a dedicated team here who will pass along your questions to the panelists who are participating today. And again this week, joining me to my right is my partner Robert Chisholm of Chisholm and Kilpatrick, and to my left is Jenna Zellmer of Chisholm and Kilpatrick, both of whom have a wealth of experience at the Court of Appeals for Veterans Claims, as well as at the VA agency level and at the federal circuit. To get started, I am told that Robert Chisholm has a special announcement about the RAMP program for VA, so let's hear from Robert on that one.
So we've been talking about RAMP since the program was implemented.
Which is?
I can't tell you what the acronym stands for, but it's
Rapid Appeals
Modernization Program. Rapid Appeals Modernization Program. Way to put me on the spot, Zach. Anyway, so far only 2 lanes of RAMP have been opened. That's higher level review and the supplemental claim lane. But as of October 1st, the board lane is open, and I wanted to update people that if they get a denial in RAMP, they can now appeal to the board. And we understand as of this week, there were 386 RAMP appeals in the board lane. Of those, 108 are in what they call the direct lane, 65 are in the evidence lane, and a little over 200 are in the hearing lane. The other thing I think it would be good to point out and let people know is that in fiscal year 2018, so the government's fiscal year runs from October 1st to September 30th, so 2018 just ended. The board signed over 85,000 decisions. That is, they made 85,000 decisions, which was up substantially from like 53 or 54 from the previous year. And we hear that the target for the board for 2019, fiscal year 2019, which is, again, just began on October 1st, is to do 90,000 decisions. So that's my quick update on RAMP. We have a lot of articles on RAMP on the website if you want to learn more about that.
So congratulations to the Board of Veterans Appeals for meeting their goal this year.
Yes.
Which actually really, and I truly mean that, it's really great work and good that they did that so that veterans can get more timely decisions on their appeals, and hopefully they'll be able to keep at it and maybe do even better in 2019. So moving from the Board of Veterans Appeals to the Court of Appeals for Veterans Claims, let's start off with a quick refresher from Jenna Zellmer about what the Court of Appeals for Veterans Claims is, what it's all about.
Right, and as Zach mentioned, we did do a part 1 of this Facebook Live last week, and so we're just going to give a brief refresher, but if you want a little bit more information on the court and the history of the court, you can go back and look at last week's presentation. But essentially, the CAVC, or the Court of Appeals for Veterans Claims, is a separate entity. It's not part of VA, and it's the court that reviews all of VA's decisions. And so if you're a veteran and you've received a board decision, you can appeal it to the court, and that's what I mostly do. And the court will review the record, it'll review our arguments, and determine whether or not the board made any legal errors or if it overlooked any relevant facts.
Jenna, can the court take new evidence? Like if you appeal your case to court, can a veteran submit like a new medical opinion in court?
That's a good question, Robert. No. So the court operates on something that we call a closed record. So essentially what the court is doing is looking at a snapshot of whatever the board had in front of it at the time that it made its decision. And just based on that evidence, the court can determine whether or not the board made a legal error. The good part about appealing to the court, though, is that if you do get a remand from the court, then the record becomes reopened and you can submit new evidence that would support your claim.
All right, with that background, let's talk about the 5 cases that we're going to talk about this week. We'll start with a case called Rice, and I did want to give a little bit more background. These are cases that are precedent cases from the Court of Appeals for Veterans Claims. By and large, that court issues what is called single-judge memorandum decisions, which are not precedential, which means that those only apply to the particular veteran that brought that case. But when the court sits in it sits as 3 judges or as all 9 judges together. They make a precedent decision which affects all of veterans law. And so we're going to talk about 5 of those cases that affect all of veterans law, and we are going to start with an all-time favorite of pretty much anybody who practices VA law, and a very helpful case for all of veterans called Rice versus Shinseki. Shinseki being the Secretary of Veterans Affairs at the time in 2009. And Robert, want to get us kicked off with Rice?
So, and I believe the cases are going to be posted on our website if you actually want to read them, so you can see them at cck-law.com. So Rice dealt with the issue of TDIU, and TDIU is an acronym, Total Disability Based Upon Individual Unemployability. And what a TDIU benefit is if the veteran has less than 100% rating, a combined rating of under 100%, and they're unable to work due to their service-connected disabilities, they're entitled to a 100% rating. And for years, the VA treated TDIU as a separate claim, separate and apart from anything else that was pending. So let's talk through a hypothetical here. Let's suppose that a veteran has a back injury and files for service connection for back condition. And that back condition is rated at 60%, and that due to that back condition, they're unable to work. And let's say that the veteran is fighting from the RO up to the board, the case gets remanded, and service connection is the issue. Then the veteran gets a 60% rating, but appeals the rating, saying, I can't work. And under the way the VA used to adjudicate these claims, it could have been pending for 5 years. But if the veteran says, I can't work due to that back injury, the VA would treat that as a new claim, as opposed to, and this is the magic language, part and parcel of the back claim. So Rice held, and this was the Court of Appeals for Veterans Claims, held that it's not a separate claim. In fact, it's part and parcel of any pending claim, as long as the veteran alleges that the service-connected disability caused the inability to work.
It was a huge case when it came out, and it remains huge to this day. It's probably one of the most cited cases, I would say, in the court's history, and continues, even though it's coming up on its 10th anniversary, to be one of the major milestones in VA law.
And I think it's important to point out that we are still filing appeals in 2018, I'll have you know, dealing with this issue and its ramifications, because the VA still has not correctly applied the court's holding in many cases, unfortunately.
And Rice is one of several cases that stands for the general proposition that veterans' claims are supposed to be read as liberally as possible by the department. Rice there are probably 4 or 5 cases that stand for that general proposition in different contexts. But Rice is important because it stands for it in the context of TDIU, which is a common benefit that is sought and also a benefit that is worth a substantial amount of money, which makes it a very important case. So that is Rice versus Shinseki. We will move to Jenna, who is going to talk about a case that's a little bit older. It came out in 1994, and it's Esteban versus Brown.
So Esteban dealt with a VA policy called the anti-pyramiding rule. And basically what that means is that veterans can have multiple service-connected disabilities, and they can have multiple different ratings for all of those different disabilities. But the anti-pyramiding rule says that if you have 2 disabilities that have the same manifestation, for example, if you have 2 different disabilities that both manifest in pain, you can only get compensated for that specific symptom under one of the disabilities. You can't get double compensation. And so Esteban dealt with this in a situation in which a veteran was seeking, compensation for multiple different facial injuries, and originally he was denied separate ratings because they said that they were all just symptoms of the face. But Esteban said that if you have different separate manifestations of the same disability, you can actually get separate ratings. So in Esteban's case, he had one manifestation that was pain. I believe he had another manifestation that was difficulty moving his jaw. And then I think another one that had to do with
I believe
muscle.
we have a helpful infographic
Yes,
up right now.
we do. And so because even though it was all around the same body area, he had different symptoms, and though each symptom was entitled to its own benefit. And so generally, you know, what we like to say is that when you're considering a veteran's disability, you're supposed to be not just considering what the disability is labeled or the area of the body it's in. You're supposed to be considering what the actual symptoms or manifestations of that disability are. And so if you have separate disability or separate manifestations, you should be getting compensated for all of those disabilities or all those manifestations. And so we have a helpful infographic. I guess it's good to back up and kind of explain how VA rates disabilities, and they rate them by something called diagnostic codes. So every disability is assigned to a different code, and every code lists ratings and then the disability's symptoms that correlate to each rating. And so, for example, orthopedic conditions, you get a certain amount of rating based on your limited range of motion. For psychiatric disabilities, you get a certain rating based on how severe your symptoms are. And so, you know, a certain diagnostic code could compensate limitation of motion for the knee, for example, and a separate diagnostic code can compensate for instability of the knee.
See how easy it is?
And so because those, even though you have one knee disability, those two diagnostic codes compensate different manifestations, and you can get two separate ratings for those disabilities. So that's what Esteban stands for.
Piece of cake.
So I'm going to confess, I've been confused about this for years.
About Esteban.
And I always have to go back and reread the case to make sure it's applied correctly.
Yes, it is a very important case and extraordinarily often cited and seldom understood.
I think a good way to consider it is you just put every single symptom in a box, and then you compare each of those symptoms to all the different potential rating criteria, all the different diagnostic codes, and you just match them up. And so if you have one diagnostic code that contemplates symptoms A, B, and C, you get a rating for that. And then there's a separate diagnostic code that contemplates symptom B, C, D, and E. I forgot where I left off in my alphabet, but you get compensated for that. And so you just go down the line and you figure it out. And if, you know, at any point you have two diagnostic codes that both contemplate symptom A, you just get one of those.
And feel free to ask any questions along the way as we're going. Let's move on from Esteban, because I have to before my head explodes, to Mittleider versus West, which is, in my mind, much easier to understand. It is from 1998, and Robert Chisholm is going to talk with us a little bit about the major holding of Mittleider.
So in Mittleider, the court held that when it's not possible to separate the effects of a non-service-connected condition from the service-connected condition, the benefit of the doubt goes to the veteran so that all the symptoms from the two are considered in what Jenna was just talking about in rating the case. So in Mr. Mittleider's case, it was a psychiatric issue. So I think it would be good to give a concrete example of how this plays out in reality. We represented a veteran a few decades ago on a case, and that veteran had a 0% rating for his post-traumatic stress disorder, which the VA found was due to his service in Vietnam. He also had a non-service-connected organic brain syndrome. And after the Mittleider case came out, we argued to the VA that the medical opinions were not able to sort out which symptoms were due to the PTSD and which symptoms were due to the organic brain syndrome. And in fact, we got a medical opinion from a professional who said the DSM-4, which is the Diagnostic and Statistical Manual that psychiatrists and psychologists use to diagnose mental disorders and psychiatric disorders, specifically said you can't do that. And so because they were unable to sort out what was due to the PTSD and what was due to the organic brain syndrome, which was non-service connected, We eventually got the VA to rate the 0% PTSD up to 100% using the principle announced in Mittleider. Mittleider also has been used in cases such as DIC cases, where it's unclear precisely what caused the death of the veteran, whether it was a non-service connected issue or a service connected issue. We've used Mittleider arguments in those kinds of cases. I believe we've also used it in the orthopedic arena as well. Mm-hmm. So the general principle about the benefit of the doubt goes to the veteran. When it comes to actually rating disabilities and the symptoms and whether they're due to a service-connected or non-service-connected condition, this opinion has helped many veterans get the benefits they deserve.
Absolutely. So that is Mittleider, and we're going to move on to another all-time favorite. We have two left, and we are still definitely taking questions if you have any. As we move through these, we're going to go and switch over to Jenna for the world-famous DeLuca v. Brown case, which comes from 1995, which is still often very, very, very often debated between appellants and the Department of Veterans Affairs at the court level. It is a major case. It led to at least 3 or 4 other cases that stem from DeLuca, but let's start with DeLuca from 1995.
So DeLuca is a nice transition from Esteban, I think, because as I was...
They're all great from Esteban.
But as I was saying in Esteban, VA rates its disabilities based on the diagnostic code. And so for orthopedic conditions, the diagnostic code is pretty... simple. An orthopedic condition, which is, anything to do with the bones, so a knee, a back, the neck, ankle, wrists, etc. All of those are rated based on how far in your range of motion you can move that area of the body. And so DeLuca stands for the premise that, just because that diagnostic code is based strictly on raw range of motion measurements, that's not the end of the necessary inquiry that the board is supposed to take into consideration. And so there are actually 2 regulations that almost kind of supplement what the diagnostic code is, and inform the board on other things that they're supposed to look at in terms of functional loss. And so just because a veteran may be able to move his back to a certain degree during an examination, that doesn't necessarily mean that in the daily course of his life, that range of motion translates to an ability to, perform all of his daily activities and perform work. And so it's possible that due to weakness, fatigability, incoordination, sometimes flare-ups of pain, that he could be far more disabled than is typically shown in his range of motion. So DeLuca kind of says that the board can't just look at the diagnostic code. They need to consider all these other factors to take into whether or not the veteran is actually more disabled than it appears to be based on the diagnostic code.
DeLuca is one of the cases that tries to be realistic about a veteran's circumstance, because one can imagine that you can make somebody bend their back or their arm. They can bend it, further than when the pain sets in. But as a practical matter, the person is disabled when it becomes too painful to move, even if they can keep going. DeLuca was the first case that really came along and took the reality of that situation into account and threw some subjectivity into veterans law to where you don't just match up the absolute maximum that somebody can do. You have to match up what they can realistically do in an ordinary daily life setting. So that, I think, is one of the most important takeaways of DeLuca, and there are now dozens of cases that tend to go along that general philosophy.
Yeah, they guide kind of what the examiners are supposed to be looking for in terms of not just measuring range of motion, but kind of taking all of those factors into account.
And
can I just add one thing in terms of if you're a veteran going to a medical exam, it's really important not to be the tough person and say, hey, It doesn't hurt at all. You need to be candid with the examiner and tell them when the pain sets in and when you start having difficulty with range of motion. That's really important for the exam. And if you believe the doctor didn't hear you, you can always submit a written statement that when the doctor moved my arm this much, it began to hurt.
Absolutely. And speaking of examinations, this is our last case of the day and an all-time personal favorite, which is Colvin versus Derwinski out of 1991. The court basically started deciding cases in late 1990, I think. And so this is really one of the first cases from the court. It is still absolutely cited almost every day in veterans law, even though it is coming up on its 30th anniversary here in a couple of years. So let's talk about Colvin, Robert.
Almost 3 decades
Almost
ago.
3 decades of Colvin.
Wow.
We'll get T-shirts.
So, in the old days, prior to the court's creation, prior to judicial review, the board would make decisions with 3 members, and many times one of those members was a medical professional. And this case stood for the proposition that the board couldn't rely on its own medical professional to give an opinion. Essentially. So they needed independent medical evidence in order to refute or to deny a claim. It was no longer based upon their own judgment. So this case stood for that proposition, and VA could only use independent medical evidence to support its benefits decisions. So as a result of this decision, we have, I think, literally hundreds of thousands of compensation and pension exams every year done by the VA, and those are independent under the guise of the Colvin decision. The board is also able to go out and hire experts either within the VA system or outside the VA system if there's a particularly difficult medical question. But they're no longer able to use just their own medical judgment. And on occasion, we still see this issue surfacing 30 years later in cases where a board judge will use their own opinion, and the court concludes that's a medical opinion. They need independent evidence to support that assertion. So when that happens, the usual result is a remand back to the court to get an independent opinion.
Back to the board. Yeah, it's basically an order back to the Board of Veterans' Appeals saying, you're a lawyer, not a doctor, so have a doctor give an opinion about this. That's the long and short of Colvin. It's amazing how often it still happens, but it does still happen quite a bit.
But there's another interesting historical footnote with the Colvin decision,
Always.
dealing with the issue of new and material evidence. So if a claim becomes final under VA law, a veteran is able to reopen a claim with new and material evidence. That's going to change after appeals reform. It's going to be new and relevant evidence, but under present law, it's new and material evidence. And in this case, the court back in 1991 interpreted what new and material evidence. And instead of relying on the VA's regulation, that is giving deference to the VA's interpretation, they grafted it from Social Security. They came up with a definition. And that remained the state of the law until a Federal Circuit court case called Hodge said, no. You can't go borrowing someone else's interpretation where the VA's interpretation is entitled to deference. And so in the Hodge case, they overruled the standard for new and material evidence in Colvin. And we look forward to seeing what the final interpretation of new and relevant evidence is going to be with appeals reform, and that should be coming sometime soon. Those regulations will become final, and we'll see what that is going forward. So that's a little footnote on Colvin.
So that is the completion of the 5 cases we had remaining from the top 10 U.S. Court of Appeals for Veterans Claims cases. I'm sure that it will be hotly debated whether we picked the right 10, but
let us know your opinion.
But these are 10 that are certainly very important. So from Jenna Zelmer, Robert Chisholm, and Zach Stoltz in Providence, Rhode Island, we thank you very much for watching today, and we will see you all again soon at our next Facebook Live. Thank you.